SJC-12579, Antonio Garcia v. Commonwealth.
Garcia, good morning, and you've got 10 minutes to
How you
present.
doing?
I'm well. You have 10 minutes, sir, to present your case, so we're all ears. You may proceed.
Thank you. First, I want to talk about the evidence that was present at the 58 hearing on September 22nd. I want to talk about the attorney-client privilege. It was violated because I never received any evidence about the 58A. I had to write a letter to my lawyer on December 19th to receive all the evidence. So I was lost and I was confused at the hearing. And after receiving the motion to detain me on the 58A, it showed that it was deficient because probable cause on the application of the search warrant, I only have 3 pages of 11, and I don't see no signature of the detective. I don't see a date on the affidavit, and on the messages or the text messages, there's no date that are on the messages. And I believe that I had the right to confront my witnesses. The Commonwealth didn't show good cause because I don't have a reason why, since they live down the street. One is in Lynn and one is in Andover. So I had the right to confront my witnesses, just like on Morrison and Garnin, the minimum requirement, due process, a written notice, evidence against me. I never had the evidence against me before the hearing, so I wasn't prepared and to confront my witnesses. And I just want to say that there's no dangers in me. And the hearsay wasn't contained with evidence, with a police report. There was no one there to go under oath and accuse me of these things and about my past history. The 58A memorandum of the Commonwealth doesn't show that I'm a dangerous person because I was never presenting where my lawyer gave me my criminal history or my probation. I know everything about myself. In 2006, I was arrested. I resisted arrest, and there was other cops. They jumped me or whatever. I'm sorry about my language, but I'm a little nervous. I did my community service. I did 2 years of probation. I did anger management. I did assault and battery classes. And ever since I finished my probation, I never had a problem with the law. I've been arrested from 2011 to 2017, and I never, ever resisted arrest. I never showed dangers to my community. I came to this country when I was 8 years old. I joined the Boys and Girls Club when I was 12, and I discovered basketball. I played basketball through all my high school years. I played AAU. When I was in 7th grade, I went to Orlando to play in Disney World with other teams, other tournaments. It made me into a better man. I graduated high school because of basketball. After basketball, I continued working. I was good in my community. I have 27 years in Lynn. I live in Lynn for 27 years. And out of those 27 years, I never had any issue with the law. Never. I'm not a person that you should be fair. I never put hands on anybody. I know that I defaulted from the Superior Court, but it was just, I was confused. My lawyer never told me when she called me on June 19 that I was indicted. She never brought me into her office to explain what I was facing. I was left out of everything. It was just to see if I was gonna, I think it was just to see if I was gonna show up to court that she never called me to talk to me about everything that was going against me. I showed up to court. You should give me credit. I showed up to court. It's not like after my probation was over, the GPA was removed, that I left town. I was arrested in another city. I was arrested in another state. I was down the street from my house, enjoying a good day, until I get my mind correct, have a conversation with my lawyer, and bring myself back to court. But it's just, everything that happened wasn't like proper. It wasn't proper. It should have been with my lawyer calling me, talking to me before everything, but it's just, I got nervous, so, but I think I made the right decision by walking out of court because it made me a better man. I'm here now. I found the church in here. I found the library. I'm living out of here where a better mind, and to, you know, be a motivator for other people too, like going to do the same thing. Because there's a lot of people, there's a lot of inmates here that are going through what I'm going through. And I think the 120 days doesn't show that I'm serious. It doesn't show anything. It's just I'm being here, and me being here shows that I'm more guilty. I can't show who I am because I have no weapon to show. Like, I need to be with my family. I need to be going to court so they can see that I am like responsible for my actions. And the witness was never there. So the Commonwealth never showed good cause for why there was never there. It was a hasty prosecution, you know? There was no police report. It was just text messages that started with okay and then with messages. But they never showed the text messages that happened before. It was innocent text messages. And that's all the Commonwealth had to show at the 58A, text messages and her say that the prosecutor was alleging that this happened. And there was nobody under oath. I think that's when somebody goes under oath and speak the truth, the truth will come out and set you free. But there was nothing going on at the 58A. My family was there. They thought that I was there so I could have a low bail to bail me out. My mom was there, and then I didn't know I was there for a 58A. I never knew it was a 58A until November when I went to the library and found out about all these things. So I think that I made a sacrifice by leaving court because I think I followed my heart. If I would have stayed in the outside world, I wouldn't have no knowledge of anything. So sometimes you have to make sacrifices. And I did the right thing, and I regret it. It worked in my favor because right now I'm in front of you guys, and I could scratch that out of the bucket. So I just want to be fair. My client privilege was violated. My constitutional right was violated, and it's just, if I never did this, I'll probably be here till next year, because I heard that they could leave you here for 2 years. So once I heard that, I had to do my studies, and I had to make sure that I fight for my freedom because I have a voice. Everybody has a voice, and I know I have no education or law, but I graduated high school. I passed my MCAS. I'm a point guard. I'm a leader, so I'm not gonna let somebody ruin my life, control my life. I gotta fight for my freedom, and I believe that if everything was written and arrangements was scheduled for me to like talk to my lawyer before the hearing on July 10. Like she would have come before the September 22nd hearing and talk to me, or even give me the motion, give me the text message, give me the affidavit. I only got 3 pages of 11. There's no signature, there's no date, and it doesn't show any dates that the text message was sent. So everything is sufficient. There's no probable cause. Everything is like a mess, you know? So I just want to say that I deserve to go home. I deserve to be out on a low bail. I deserve to be home with my family. I haven't done nothing. I was working 2 jobs. I lost my 2 jobs from my ex and another person. And in those cases, one got dismissed. In this case, I'm showing you guys that I am innocent of all this, that I deserve a second chance, because everything was closed, but another open when I hit the library, and I had a second chance. I believe in God's timing, and this is my time to show you guys that everything here, this is a real affidavit with a date, with a judge's signature. This one is insufficient. There's no date. I only got 3 pages. I don't know what happened to the other pages, but maybe there's a signature in the other pages, but this is what I'm talking about. Oh, I'm sorry.
Okay, thank you, sir. Ms. Semmel, you wish to be heard?
Good morning. Catherine Semmel for the Commonwealth. I will just briefly say that as set forth in the Commonwealth's brief, the defense has identified no error or abuse of discretion in the lower court's determination that the defendant should be held pursuant to 58A, that he properly considered the open cases, the mandatory minimums the defendant faced, and particularly the witness intimidation in this case, in determining that no condition of release could reasonably assure the safety of the victim or the community. And I would just
Now,
note that in my
I
brief...
believe his
apologize.
claim is that there was no evidence as to the date of that text.
As to the date of the
Date
text.
of the intimidating text.
There was testimony, there was grand jury testimony that was introduced from a detective who investigated and interviewed the victim in this case, that established the timeline of the text messages. And I would just note on my own behalf that I apologize, but I misstated the witness intimidation victim's last name in my brief as Logan at several points. It is actually Hogan. The lower court also did not err in determining that the 120 days has not passed for reasons stated by the Commonwealth, and its opposition is attached in my supplemental record appendix. And for all these reasons, the single justice did not err in denying relief pursuant to GLC 211-3.
Okay, just two fast questions. Is there a trial date?
It's scheduled for December 10th. At the moment, I'm not sure. The trial prosecutor mentioned to me that there may be some question as to whether the defendant is going forward with his current counsel, who is, I believe, his second counsel. But we are certainly ready for trial on December 10th.
Thank you.
Thank you.